Ladies and gentlemen, Vice-Chancellor, Bishop, distinguished guests, ladies and gentlemen, thank you very much. It's always encouraging to be applauded before people know what they're going to get. But there it is. It is at least an encouragement to the speaker. It's been my aspiration in this series to talk frankly about judging. The whole thing has been essentially a personal reflection rooted in the personal experience of being a trial judge. My principal concern has been to examine the discretionary powers committed to trial judges, mainly in the field of child welfare and the best interests of the mentally incapacitated. We've looked at the role of the judge and at the tension between transparency and privacy in the exercise of these powers. We've seen how judges determine factual disputes and inquired into the role of the judge as gatekeeper to state intervention in private life and as the regulator of the exercise of those powers where there is a lawful intervention. All this has been done with two essential questions in mind. First, what are the ethical and legal basis of these discretionary powers? And secondly, are they exercised with the informed consent of the society in whose name they are utilised? As we come to this final lecture, I'm going to leave my comfort zone of family and incapacity law and venture into the field of criminal sentencing. In that, I can draw on 10 years' experience as a Crown Court judge, and during the time of my being a High Court judge, I was from time to time called upon to make up numbers in the Court of Appeal Criminal Division, and so have a little experience from there. Then I want at the end to draw the threads of this series together. Sentencing is an emotive and controversial issue, always a potentially toxic combination, and no one knows that more acutely than the sentencing judge. Sentencing in many cases, especially those involving death, sexual offences or children, is passed in a highly charged atmosphere with both sets of families usually present in the courtroom, hence its emotive nature. It is also the one judicial function in which half the population and the whole of the media think they are experts too, hence the controversial element in sentencing. Now, it's my strong impression that the general level of sentencing has increased significantly over the last 40 years. Our prison population has doubled during that time, whilst by any measure you choose to use, the overall level of crime has decreased. Whether those two phenomena are linked is a matter of intense political debate. There are many reasons for this increased level of sentencing, including the change in the types of offences that dominate the Crown Court calendar, like, for example, terrorism, or indeed sexual offences, and I'm told that at present 40% of the Crown Court's time is devoted to alleged sexual offences. But I want, if I may, to suggest 4 further reasons for this increase from my own reflections. The first is that our society has become more punitive over the last few years. Actually, I think probably we have reverted to type, and that it was the last quarter of the 20th century, with its many experiments in reducing the use of custody, which was the true exception. A brief look at sentencing in this country reveals a deeply punitive approach. Even as the 19th century dawned, there were over 300 offences punishable with death, and transportation was a flourishing business. Those who support a different approach to that make the point that London was a much more dangerous place in 1800 than it is today, even if one has to recognise the scope for recidivism in those days was rather less. Prevention of crime does indeed depend on very much more than the current sentencing regime. Indeed, I have to confess that I have become convinced over the years that our sentencing regime has little significant effect on the actual commission of crime. This is partly because most crime is instinctive or opportunistic, fueled by drink or the need for drugs, in which the one thing that never crosses the offender's mind is the consequence of being caught. Deterrence is of very little effect, save perhaps in those cases of carefully considered crimes, like the organised fraud or the commercial supply of drugs or terrorism or other carefully organised criminal activity. There is in those limited fields a case to be made that such people should know that the stakes are high. It also has to be said that most people in our society have very much better reasons not to commit crime than merely the fear of punishment. I have suggested to my students from time to time that if they're short of money, why don't they go out and rob the nearest old lady available? And they all have very much better reasons for doing so than the fear of going to prison. And we need to recognise that most people order their affairs by matters far more significant than the criminal justice system. I think the second reason for higher levels of sentence is not only a public refusal to accept that anything that is not imprisonment is not truly a punishment, but also the significant inability of offenders themselves to manage a non-custodial sentence. From all the reports we read on offenders, so many have intellectual impairment, family disadvantage, and lack of social skills that rehabilitation is innately difficult, quite apart from their prevailing general indifference to consequence or concern for the future. The third reason I think we've seen a significant increase in sentencing are the sentencing guidelines themselves, which now cover the greater part of the criminal calendar. In principle, these make sense because in the past there has been much justified disquiet over inconsistencies in sentencing around the country and between courts. I retain vivid recollections from my own days as defending counsel that it was much more expensive to burgle in Cheshire than it was in central Liverpool. They kind of looked on it rather differently. But, however, the trouble with the guidelines, whatever their merits, is they do seem, whether intentionally or not, to have ratcheted up the sentencing tariff. The reason for this, I think, is that there was great public criticism when it was thought that a new guideline actually reduced the tariff, as, for example, in domestic burglary or drugs, as you may remember reading general storms in the paper about it. But there will never be any criticism if the effect of the guideline is to raise sentencing, and so there is a natural tendency to do just that. Starting points for sentencing are higher than they used to be, and perhaps higher than they need to be. The last reason I think we have seen a significant increase in sentencing levels is rather more philosophical. Classic penal theory concentrated on the culpability of the offender, and the sentence was designed principally to mark his or her culpability. Now we have a much greater focus on the consequence of the offence rather than on merely what the offender intended to bring about. Let me give you three types of case to make this point and explain and illustrate what I mean. The first relates to death caused by driving. There may be many levels of culpability, ranging from momentary inattention at a traffic light through to a reckless disregard for other road users or for road traffic laws generally. Let me pick a couple of examples from my own courtroom. It is not usually difficult to explain a heavy sentence on the reckless, uninsured driver who drove at 70 miles an hour up Princess Avenue in a 30-mile-an-hour limit and killed a baby who was being pushed across a zebra crossing by its mother. It is much more difficult to explain the substantially lighter sentence on the driver who misjudged the amber light. The reality is that culpability may be radically different, but the consequences for the victim are the same. and therefore the greater the focus on consequence and the less the focus on culpability, the higher the sentencing regime is likely to be. A second example, again from my own courtroom, if I may, is the consequence of very serious injuries being inflicted on very small children, for example, by shaking. The culpability in a shake may be the momentary loss of control whilst under considerable stress. The consequence may be a lifelong disability in the child. And it is very difficult to find a sentence that justly reflects culpability without belittling consequence. Or again, take the case of two young men, usually in drink, who square up for a fight after an argument in the pub. But one, either because of an unknown condition or because he falls freakishly and catches his head on the curb, dies from a punch. The disparity between culpability and consequence is again obvious, and the increasing reflection of consequence in the sentence inevitably has resulted in a significant increase in the tariff for what is called one-punch manslaughter. Now, of course, no judge can disregard entirely the consequences of a crime. But I have to say that I am personally uneasy at the modern trend. For me, the principal purpose of the sentence is to punish the offender, and therefore his culpability should be the dominant consideration. The current sentencing statute under which judges operate require that the sentence shall be commensurate with the seriousness of the offence, and that is actually not quite the same thing. However all this may be, and however important it may be, we're concerned in this series to reflect on the discretionary powers of the judge. In an age of sentencing guidelines, with a new weight given to consequence, increasing statutory controls over sentence, as well as the increasing complexity of the whole sentencing process, how much room does a judge still have to exercise discretion in the individual case? Is sentencing becoming less of an art, as we've always believed it to be, and more of a science? One of the lessons of sitting in the Court of Appeal Criminal Division is how much the time of that court is spent in unravelling sentences which are in fact unlawful, because the judge has simply lost him or herself in the complexity of the sentencing regime. And I still remember being party to a decision of the court in which we discovered that Parliament had repealed a statute which it in fact had forgotten to bring into force at all, and therefore ended up repealing the statute before that by accident, which it didn't intend to do, with the result that it was chaos, and the judge could hardly be blamed for the mess into which he or she had got. That is the world we live in, with a Criminal Justice Act that appears pretty well every year for the last 15 years or so. In order to consider the whole element of discretion and whether sentencing is still an art, we need to go first to another philosophical question, which is, what is the purpose of a sentence anyway? Many answers can be and are given to that question. Deterrence. You have been beastly, and therefore we are going to be especially beastly to you, so that you and everybody who hears about it will be deterred from your beastliness in the future. Or retribution. You have been beastly, so we shall be beastly to you, but in just proportion to what you have done. Reformation. You have been beastly, but we are not going to be beastly to you, in the hope that you will see there are better things in life than being beastly. You can add to those various aims, expiation, compensation, not to mention, of course, this current statutory starting point that we have noted of the sentence being commensurate. Now, I have to say that each of those approaches is morally justifiable. However, I think it is probably obvious that they will tend all too often to pull in different directions. The choice of the purpose of the sentence will have a significant impact on the actual sentence passed, and that choice still belongs to the judge. Then you feed in two further factors. First, guidelines are what they say they are. They are not a grid from which the judge simply reads off the appropriate sentence, as it's said to happen in some states in the United States of America. A judge may depart from guidelines up or down, provided reasons for so doing are given. Secondly, the bases on which the Court of Appeal can interfere with sentence acknowledge a high degree of discretion. They are that the sentence is wrong in principle, or that it's manifestly excessive, or that it is unduly lenient. Those matters, when you draw them together, demonstrate that in addition to the choice of purpose, a considerable discretion is still left to the individual judge. The requirement, as in other areas of discretion, is to explain your reasons for your decision. What all this means in practice is this. The judge must start with the guidelines, and that will provide the starting point. The judge must then deal with any aggravating or mitigating feature identified in the guidelines or specific to the case, and adjust the starting point up or down accordingly. That will produce the sentence that's actually passed in very many cases. However, the judge retains a discretion to act differently. Perhaps this is a case in which deterrence really is justified, or perhaps this is a case where there is a real prospect of the defendant reforming himself. A choice of either of those two approaches will significantly affect the final sentence, perhaps radically, and I believe rightly so. Now, the judiciary have always upheld what has come to be known as the prerogative of mercy, however little, in fact, it may actually be employed. It finds fine expression, as many of you will know, in Portia's speech in The Merchant of Venice. The quality of mercy is not strained, it droppeth as the gentle rain from heaven upon the place beneath. It is twice blessed. It blesses him that gives and him that takes. It is an attribute to God himself. And earthly power then show likest God's, when mercy seasons justice. It also finds rather more prosaic expression in the words that tend to be on the lips of most judges, there but for the grace of God go I. Now, one has to recognise that mercy involves a mitigation of justice, the conscious passing of a sentence that is less than commensurate and less than that actually deserved. It is, in modern penal policy, necessarily controversial. It is, however, a principle which the judiciary are keen to uphold. Now, when might a judge exercise the discretion to show mercy? Again, let me give you some examples, if I may, from my own experience mostly, as to how this can arise. First, where there is something deeply unusual about the case itself. So I remember defending an elderly man many years ago charged with murder as a result of discovering that his wife was 15 years old, older than he had ever believed that she was. He strangled her with his tie, and in his distress, he then tried to gas himself but failed to put enough money in the meter and therefore failed and was prosecuted for murder. Well, it was a case for mercy, and mercy he received. The second type of case is where there's some truly exceptional personal element. So I've exercised mercy where an offender has been diagnosed with a terminal illness, or where he is the care of someone who has been so diagnosed. Those, I think, would all be the kind of case in which you would not be surprised to find the prerogative of mercy being used. But the third type of case is more controversial, and it's where the plea for mercy comes not from the offender, but from the victim. You meet it quite often in a causing death by dangerous driving case, because quite commonly in those cases the driver and the victim were friends, and they were in the same car and involved in the same incident in the same vehicle. And the argument that is put forward is one family has been destroyed, why destroy another with a very long sentence? Now, these cases are notoriously difficult because death produces dramatically differing reactions amongst victims, all the way from open forgiveness of the sort that I've been talking about to vengeful hate and a determination to see the greatest possible punishment exacted on the person who has destroyed their lives. It is, of course, difficult to justify a radically different sentence on identical facts, merely depending on the victim's reaction. On the other hand, it would be wholly inhumane, would it not, entirely to ignore a victim's plea for mercy in those circumstances. Of course, even greater scrutiny is required where the victim, for example, in a domestic violence case, may still be under the influence of the offender. And in those circumstances, which are sadly not unusual, judges tend to be at best sceptical of any such pleas. The fourth instance in which mercy may be shown is in fact the most common, and that is where the judge is convinced that the offender is now motivated to change his life, a case where the judge is considering reformation as the key principle of the sentence, or the key purpose of the sentence. It has to be said that this is not always an easy call to make, as every advocate worth his or her salt will advance the crossroads of life argument if it is remotely plausible. On the other hand, one has to recognise that most offenders do grow out of crime in the end, and usually it is provoked by having a good partner, a supportive family, or a proper job. These, and not the fears of repeated imprisonment, are the most effective antidotes to criminal behaviour. So society stands to benefit from a proper use of mercy in such a case, but of course has little time for the judge who calls it wrong. Yet in my view, judges should not be cowed by a risk of failure or adverse publicity, as a reformed and responsible citizen is a prize not likely to be spurned. One of the frustrations of being a judge, of course, is that usually you have no idea whether your call was right or wrong. Sometimes discretion in sentencing is actually severely tested by the case itself. The most obvious modern example, of which we have a lot at the moment, is in sentencing an elderly man for crimes of a sexual nature committed 20, 30 or even 40 years before the date of trial. A policy decision has been taken to limit but not remove discretion. It is surprisingly recent. I remember towards the end of my time at the bar arguing one of these cases, and at that stage nobody was familiar with how you deal with these cases at all. In any event, as I say, a policy decision has now been taken to limit discretion. Generally, only a small discount is made for age, even though in many ways the person being sentenced is quite different to the person who committed the original offences. Many of these cases have provided a degree of notoriety in the newspapers. In the last year or so, we have a greater population in prison over 65 now than we have ever had before, and indeed one wing of Norwich Prison is effectively an old person's care home, comprised almost entirely of killers and sex offenders. Now, of course, you have to accept that this approach can operate the other way round as well. I remember having to sentence a man in his early 40s who had already served a term of imprisonment for sexual offences. But this offence with which I was concerned, or these offences with which I was concerned, predated all that and went back to when he was 16 years of age, because it arose out of one of the big investigations into a care home where they picked up offenders who were residents there as well as staff. And my view was that the only fair approach to a sentence on this basis was to sentence him as though he were a 16-year-old of good character, because that's what he was when the offence was committed. And if you're going to make no serious allowance for the passage of time, then you make no serious allowance for the passage of time. And so a sentence was passed. It wasn't challenged, and I have no idea whether anybody else thought it was right or wrong. Another example where sentencing requires a highly individual approach, where the discretionary powers are called into service, is where the offender is unusually young. When I was judge in charge of family law in Wales, I had referred to me for sentence a 13-year-old boy who had pleaded guilty to the rape of his 10-year-old sister. And what had happened was that they were found at it together by their foster mother, who, not surprisingly, alerted the authorities. And of course there was a prosecution, and of course he had no answer to the rape charge, because there was no way she could have consented, however unresistant she actually was. Well, I managed to find out that this young man was caught up in care proceedings, and I managed to get hold of the care file, which showed me that incest was endemic in that family over at least 3 generations. And these children were doing no more than children in that family did. They just happened to have been seen by the foster parent and not by somebody else in the family. Now, of course, the boy was a serious risk to other children, because there were no boundaries of any sort in his understanding. But his culpability was very low, because he had no idea that what he was doing was wrong. A therapeutic and not a punitive sentence was required. And happily for me, the local authority put together a therapeutic package which enabled me to act without having to use custody. Of course, a non-custodial sentence on rape is calculated to incite the press somewhat dramatically, although I think even they on this occasion thought there might be something in this approach. Inevitably, of course, there are young offenders, very young offenders sometimes, who must be locked up because they're a danger to society and often to themselves. The strongest and most powerful example we tend to have is the habit of criminal gangs putting the gun in the hands of the 15-year-old on the basis they have less understanding of the impact of pulling the trigger, less concern about the consequence, and may be dealt with less harshly by the court. But however much culpability may be restricted, one also has to recognise with young offenders that the prospects of reformation are often rather better. Well, I trust that this brief survey will at least show that even in these days of statutory requirements and sentencing guidelines, a considerable discretion in sentencing in the individual case remains with the judge. And although circumscribed by statute and science, it seems to me that sentencing does indeed remain an art, and I doubt that I am alone in having found that it was often the most difficult part of being a Crown Court judge. There are, as I have tried to show, all manner of questions of principle and practice which frequently tend in opposing directions. Quite often difficult matters of judgment arise, requiring choices to be made that translate into decisions that are bound to upset somebody. Of course, no judge will always read the case correctly. As I've often pointed out in this series, judges are prone to the frailties of human condition as much as anybody else, and no one tends to be more conscious of that than the judge himself. On the other hand, discretion enables the judge to do what seems fair, just and right in the individual case. And so we must come back finally to the basic questions that have underpinned this series of lectures. What is the true ethical and legal basis of these powers, and are they exercised with the informed consent of the society in whose name we act? These two questions are interrelated and, I suggest, of fundamental importance in a democratic society. I've tried to address these questions through frank reflections on my own judicial experience. I've chosen the route of child welfare and the best interests of those who lack capacity to make their own decisions, as well as that of criminal sentencing, both because they reflect that experience of mine, and also because they're probably the most controversial manifestations of the discretionary powers of the modern judge, and are likely to become increasingly so as society becomes yet more diverse and yet more complex. These discretionary powers may have their root in statute, as indeed they do, but as I hope I have shown, they allow a very considerable breadth in decision-making. The purpose is to allow the judge to do justice as he sees it in the individual case. Now that comes at a price, not only of some lack of certainty of outcome, but of some lack of certainty in the values inherent in the decision-making process itself, as the judge seeks to balance what is understood to be the values of society, what appears to be the values of those involved in the case, and of course the judge's own personal value system. And this is as true of sentencing as it is of any of the other subjects at which we have looked. It often involves resolving the tension between perfectly good, but frequently in an individual case, irreconcilable principles. The tensions between transparency and privacy in the administration of justice, between protection and autonomy in the determination of best interests, or between punishment and reform in criminal sentencing, are but examples of those tensions. In the end, choices have to be made and choices have to be acted upon, because as we have seen, the one thing that the judge cannot avoid is the making of an individual decision in each individual case. We do not have the luxury afforded to some of being able to say this is all frightfully interesting and terribly difficult and pouring oneself another glass. The answer is that a decision has to be made and you have to put your head on the line, if I may use that colloquialism. It is therefore important to ask whether these powers are indeed exercised or these choices made with the informed consent of the society in whose name we act. I confess to being significantly troubled about that, not least because I am wholly unconvinced that the full range of these powers and the choices that have to be made are indeed widely understood in our society. One of my aspirations in this series has been to describe those powers and those choices in a manner that is accessible to any interested citizen. For otherwise, any consent may not be a truly informed consent. At the heart of this issue, it appears to me, lies a question of trust. For an informed public, nevertheless, will have to trust judges to exercise these powers in a way to which the public may give their consent. In a democracy based on separation of powers, judges must be independent not only of executive control, but of overbearing pressure from the media, pressure groups, and the general noise in the public square. Of course, we must be aware of and take account of such matters, but it is essential to retain independence. And independence requires trust and trust requires that choices and values should be politically and ethically acceptable. Trust may be essential, but it must also be deserved, even earned. There is a requirement on judges not only to act with integrity and beyond corruption, but with a real understanding of the needs and aspirations of the society that they serve. I go further. I do not think that the powers we have been discussing over the last few weeks can be effectively exercised without an understanding of society and a genuine empathy with humanity, even when it goes horribly wrong. The recluse and the cynic have no place on the modern bench. A humane understanding of people, a deep sympathy with human fallibility, and a desire for a just and ordered society must be the essential features of a judiciary which can then deserve, enjoy and retain the trust of the society amongst whom we are authorised to exercise these extensive and remarkable discretionary powers. Thank you very much.